Okay, good afternoon, everybody. Please, can someone confirm if they can hear me?
Yes, ma'am.
Okay, thank you so much. So, good afternoon once again. I'm Sophie Desmond, the head of communications for Gypsy. So, today, welcome you all to today's class. And the topic for today would be exploring open AI and big data, the implications of data privacy, intellectual property, and ethical AI in modern applications. So today, we'll be having two mentors on the call, hopefully. Um, the first is Mr. Gabriel Udo. So I'll go ahead to read his profile. So Mr. Gabriel Udo holds a PhD and is a distinguished legal scholar and technology policy expert with a specialization in artificial intelligence, law, governance, and ethics. He's a permanent fellow of the Robotics and Artificial Intelligence Law Society in Berlin, where his work focuses on the legal, ethical, and policy risk associated with emerging technologies. Gabriel advises corporations and public institutions on AI governance, framework, risk management, and regulatory compliance, with particular expertise in data protection, impact assessment, AI case management, and ethical data governance. His professional experience includes consulting and collaborative projects with global organizations such as Mozilla, alongside extensive research on responsible AI, smart cities, digital colonialism, privacy, autonomy, weapon systems, and intersection of technology with human rights and society. Gabriel has held fellowships at leading European research institutes and has presented academic papers across Europe, Africa, Asia, and the United States. He is currently a member of the International Chair on Generative AI Challenges and Risks at the Universidad San Pablo, Spain. So thank you so much, Mr. Gabriel. Although he's yet to join the call. So while we wait for him, I'll just go ahead in reading Mr. Ridwan's profile. Sorry, let me share my screen. Okay. Okay, so Mr. Ridwan is a tech lawyer, a multidisciplinary privacy professional, and a CTO. His expertise extends across various specialized technology law domains, encompassing artificial intelligence, blockchain, cloud computing, and other cutting-edge technologies. Being a certified information privacy technologist with the IAPP and an esteemed OneTrust Fellow of Private Technology, Ridwan is at the forefront of translating privacy regulations into functional applications that handle users' data, a significant void he diligently fills. Furthermore, his unique position in working across numerous complex projects bridges the gap between legal and technical terms, thereby harmonizing two distinct domains in this expansive technological landscape. Ridwan ardor for the effective implementation of privacy and security best practices is evident in his active involvement in shaping industry standard set forth by eminent organizations such as the National Institute of Standard and Technology, the Cloud Security Alliance, and the Center for Internet Security. So thank you once again to our mentors, and we'll be looking forward to receive them on the call. So moving forward, um, I don't know, our people to present, sorry, group one and group two, are you guys ready? You
Okay,
are
good
presenting.
morning. Good
Okay,
morning, Sophie.
good morning.
Yes, thank you very much for helping us this class and also reading out the mental profile. My sincere apologies for joining in that. So we'll just be picking up the session from here. Please, Sophie, I would just like to request that you help follow up with the mentors so that we can have them join the session as soon as possible, and we can have a smooth transition in class. So not to waste any further time, what we'll be doing right now is that we'll be running through presentations first, or we'll be running through your presentations first. And then after your presentation, we would have the mentors come discuss the topic. After discussing the topic, we'll take questions and then we'll call it a day in class, right? So that's how we'll be moving through this session today. So I see that we are quite scanty in the session. Please, I would like for us to try our possible best to reach out to our other co-mentees, letting them know that the session has started and we are going to be moving hard in class, right? So please, for the mentees, right, we have one group that will be presenting, like I earlier mentioned, and we'll be taking presentation from group 2. I know that the presenter for group 2 is in the class, right? So please, you can go ahead, share your screen and start your presentation. I would be turning on, I'm trying to still set up, right? So I'll be turning on my video also very soon. So thank you as you start your presentation. Over to you, group 1 or group 2 rather. Did we hear me? Please, can someone confirm that they heard me?
Yes, you're audible, sir.
All right, so Angela, are you with us? Please, we would like to take your presentation now. If you need help sharing your slides, you can just notify me and I would help you do that right now.
Okay, good afternoon, everybody. I'm having issues with my laptop currently. I'm trying to share the screen, but it's not coming on. So I wouldn't mind
All right.
if you can help me share from your end.
All right, so give me a minute to bring it up. Let me kindly
Okay, sir.
let me open it right now.
Okay, sir.
All right, so sorry again. I'm still trying to get my slides up. So please just kindly give me a moment.
Okay, sir. I'm also trying from my end, so anyone that works faster.
All right, so can you see my screen?
Yes. Yes, I can.
All right, please go ahead.
Okay. Good day, everyone. So I'm presenting for group 2. My name is Jagede Angela Olua, and our topic is on intellectual property and ethical AI use. The next slide, please. Okay. And today's content will be talking on intellectual property and ethical AI use, who owns AI-generated content, copyright issues in AI-generated art and writing, case studies or lawsuits involving AI training data, and ethical guidelines for using AI tools responsibly. So the next slide, please. The next slide. Okay. So intellectual property deals with the protection of individuals, inventions, designs, and artistic works. It gives them the right to profit from them and prevents others from using them without permission. Basically, intellectual property has to do with artistic works most times. For instance, books, movies, films. It can also deal with things like patents for an invention, like a drug, like a machine, like a tool. It could also be, it could also apply to logos, for instance, logo designs, designs that we see on fabrics like Ankara, for instance. It could also you could also talk about like things like recipes, for instance, trade secrets, what people use in their businesses, like Coca-Cola, the recipe they use to get that distinct taste, the recipes that people use in, let's say, Mr. Biggs, that's a trade secret that has to do with intellectual property. And so the intersection of AI and intellectual property is a rapidly evolving field, primarily centered on two major issues. That is the legality of using copyrighted data to train AI inputs, and whether AI-generated content can be protected by IP laws. We would be getting answers to these two major issues as we go on. And they said that the pillars of intellectual property involves copyright, trademarks, patents, and trade secrets. I've already said such. Like copyright has to do with artistic works that we can see, books, films, even dances can be copyrighted. Trademarks could be like a logo. What differentiates a particular product from another? That's like a trademark. Patent is for an invention. So I've talked about drugs. Most times it's like medicine, drugs, tools, machines. And trade secrets has to do with recipes, has to do with confidential information that should not be leaked out to the public. And some ethical issues involved in AI and IP could is under questions of authorship, transparency, and authenticity. So, the next slide, please. Okay, so it says who owns AI-generated content. Now, mind you, IP, intellectual property, is built on three assumptions. Create that human efforts brings up is built by creativity. That is that there is creative efforts in human work. Another is that original works should be clearly attributed to a person, and the creator should also get rights for their work. So these are like elements that IP is built under. But then when it comes to AI generated work, it comes off of those elements, especially when we talk about generative AI systems. For instance, now we look at our ChatGPT. We come to your ChatGPT and you write a prompt, give me an image of a girl. Now, when you do something like that, it's called using a generative AI system. You're asking ChatGPT to generate something. And most often times, it does not, that generative AI system, that ChatGPT, does not create in the human sense. What it does is it accumulates data from data that it has been trained to know. So, for instance, let me give an example. ChatGPT does not create anything that it has not been fed with. So when an AI system is trained, it is trained using different data sets. And it is that data set that you can now use to create something else, to create whatever prompts you give it. So when it comes to who owns AI generated content, it says ownership of AI generated content depends on how the content was created and the rules of the platform used. So if we look at Adobe Photoshop, when you design something in Photoshop, you usually own it even though you used a tool. In the same way, many platforms like ChatGPT allow users to own content they generate as long as they follow the platform's terms. Okay, and then however, there are important limits. In some countries, copyright law requires a human creator. If content is generated entirely by AI with little or no human input, it would not be protected. So I want to double down on the fact that sometimes you might own the content that you generate when you follow the platform's terms. That is correct. And then other times when there is little human input, you do not own that AI generated content. So there has been a debate that, okay, if you, like I made the illustration of ChatGPT where you write in a prompt, generate a picture of a girl. You cannot, whatever image that ChatGPT brings out, you do not have copyright over that image. You do not own that image because you performed little human effort. All you asked was for a girl. Now imagine if you now write, oh, give me an image of a girl. I want her to have black hair. I want her to be 6 foot tall. I want her to be wearing a particular type of clothes. I want her to be to put on jewelry. I want the background to be so and so. I want her to be smiling. In that case, you can own that particular AI generated content simply because you have performed a sort of human input. At that extent, you have in a way edited that particular content, and so you own ownership of it. It is not the AI company that owns copyrights to that particular work. And so we can go on to the next slide. Okay, intellectual copyright issues in AI generated art and writing. So the intersection of AI and intellectual property IP focuses on two primary legal fronts. That is the training data and the generated content. So it says here under inputs, training and copyright, AI development relies on massive web scraping, sparking legal battles in the New York Times versus OpenAI case, where developers argue fair use, claiming the process is transformative. Plaintiffs allege unauthorized exploitation. Oh, okay. So when we talk about copyright issues that comes from generative AI work, the first one is training data. This is because paintings, articles, music, data that are being trained on is taken and used and manipulated without consent from the company or from the companies that they are getting the data from. And so in this case, the New York Times versus OpenAI, there was a debate about whether you can use those data under fair use. And so the AI companies would argue that, okay, that it is transformative, that when they use those training data, it transforms it and it is non-expressive. And creators would argue that by doing such, it brings about competition and they can even be replaced. I think sometime last year on Twitter or even outside Twitter, there was this trend where people would take an image, they would give ChatGPT or they would give an AI, and then they would tell it to turn it into a Ghibli creation. Ghibli is Ghibli. So they will turn it into something of that sort. Now, that Ghibli is actually a unique style that a production company in Japan have been using for their animation. They actually make films and stuff like that. And that's the art style of most of their films, of most of the animations they put. So by telling AI that it should train the data and then use it to turn whatever image it has been given into that Ghibli image, it could be said to want to compete or replace the company, because so before you know it, people started making so many images, and these were not images that were accredited to that particular company. They were just images that were made by AI. And so it became an issue, a copyright issue. And then we can also see outfields where it talks about authorship and patents. Current legal frameworks generally require human authorship. Yes, most legal frameworks have come to a sort of consensus that human has to be the owner of whatever intellectual property that is made. The next slide, please. Okay. Then copyrights, works created solely by AI prompts are ineligible. However, AI-assisted works with significant human creative inputs may be protected. That's what I was talking about when I said that if you give AI a prompt that, okay, oh, please change the style, change this, change that, then we can say that AI assisted you in that work, and they may not, it's not what's the word? It may be protected, meaning that it is not a given that it should be protected. It's made depending on whatever law that is in force. And then even patents, when we talk about courts and the Dabos case has to do with the case of Stella versus Comptroller General of Patents. In that case, it was established, I think it's a 2023 case. And in that case, it established that patents that you cannot file a patent that an AI made. You cannot say that a patent should be filed from an AI. I think in that case, the plaintiff wanted to file an invention that his AI made, and the court said that it's not possible, that patents require human effort, they require human input. But if in a case where the person comes out and he says he was the inventor, but he used AI as a tool, then that particular invention may be protected under patent. But if you should say, oh, the inventor was an AI tool, AI machine, it cannot be protected. And then we look at trade secrets. While AI logos face originality hurdles, AI-driven processes can be protected as confidential trade secrets. So this kind of shows that sometimes AI processes can help protect confidential trade secrets, but it's not in all cases. So in order to prevent future arguments regarding creative works, individuals and business owners should document human involvement, conduct IP audits, and use plagiarism tools to ensure outfields don't inadvertently infringe on existing works. Okay, I think that's straightforward. The next slide, please. Okay, so this one has to do with case studies involving AI training data. So we have a case of Getty Images Limited versus Stability AI Limited. Now, this is a case where Stability AI used several images from Getty in order to train. So the AI company used Getty Images to train its AI so that it could bring out images that were similar to that. And sometimes it would bring out the presence of distorted Getty watermarks in AI-generated outputs, provides strong evidence that copyrighted material was used, raising claims of both copyright and trademark infringement. The case is ongoing and widely regarded as one of the most significant AI copyright cases in history. In this case, I don't think it's ongoing anymore. I think it has been settled, where they said that copyright and trademark infringement did not apply in this case. The Getty Images could not prove some substantial evidence, so they could not prove copyright and trademark infringement. But the case itself talks about how AI uses different training data to train to equip their own AI, and inadvertently it trains them to be able to create images like that. Getty Images now it's a photography company, and when they photograph a person or when they photograph anything, they always put a certain watermark there. And because they have trained AI like that, those AI now started giving such, even when it was not made by Getty itself. So this was what brought this case and sparked controversy as well. Please, the next slide. Okay. This one is Thomson Reuters versus Ross Intelligence 2025. And it talks about a Delaware federal court delivering the first major ruling against an AI company, finding that Ross Intelligence infringed on Westlaw's copyright. Okay, so Thomson Reuters is the owner of Westlaw. Westlaw is a company. So Ross Intelligence infringed on Westlaw's copyrights. It used some of the input, some of the outputs by Westlaw, and it now made how would I put it? Okay, so Ross Intelligence made use of Westlaw's documents and so many other things to bring out its own. And so Ross Intelligence now came into the court and said that they didn't do anything wrong and they were just exercising fair use. And so the court rejected fair use, ruling that the AI training was not transformative, and instead it brought about even competition to Thomson Reuters market, because now instead of the AI to help them, the AI acted as a competition, because why would I use Westlaw when I can use Ross Intelligence, and Ross Intelligence would even give me a better summary, would even help me do this, blah, 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 even though they were taking information from the plaintiff, that is from Westlaw. So the next slide, please. Okay, so this last case talks on the New York Times versus OpenAI Inc. and Microsoft Corporation. I think this case is still ongoing. New York Times filed a landmark lawsuit against OpenAI and Microsoft, alleging that millions of its articles were used without permission to train ChatGPT. So this is very similar to the Getty Images versus Stability AI here as well. They trained ChatGPT using data sets from New York Times. So the thing about New York Times is, for certain articles or for certain publications, you would have to pay a subscription. But by using ChatGPT, you can bypass that subscription and you get articles that are almost on par with the New York Times. So the Times then contended that it constitutes a copyright infringement and it threatens its business model, because that is what makes New York Times distinct from other publishing houses, from other publication houses. Just like I made an example of Ghibli, where Ghibli's art style was what made it different from other animation houses. And so by using ChatGPT or using any Gen AI to try and get a semblance of that was a copyright infringement, no matter how a person might say, oh, copying is flattery or is just part of the process, it would still constitute a copyright infringement. And if they can prove it, then they can as well be successful. So here, OpenAI still argues that the use of the data constitutes fair use. But like I said, the case is still ongoing, so it's subject to the ruling of the courts. So the next slide, please. Okay, the ethical guidelines for using AI tools responsibly. The integration of AI into academic writing offers transformative potential. Yes, this means that with AI, we can do more research than we did years ago. It allows us to be able to perform so many other functions, so many other duties that we were not equipped to perform beforehand. Yet its ethical deployment requires a rigorous commitment to transparency and intellectual honesty. The primary guideline for responsible AI use is the full disclosure of the tool's role in the creative process. Rather than using AI to bypass critical thinking, writers should treat these tools as sophisticated brainstorming partners that assist in structuring arguments and refining syntax. So this talks about how one should not use AI as everything. It means that as you're using AI, you should also bring into play human efforts, critical thinking. You should try and tweak whatever you are bringing out as as a product of intellectual property with human effort. Just like the example that I gave, when you are coming to ChatGPT to give you an image of a girl, you do not own any work, any image that it brings out. You have to tweak it with human effort. You have to add your own into it. Even when you're writing an article, you cannot use AI and then expect that you have not copied or expect that it will be plagiarism free. You have to write your own thoughts. You have to put in whatever you think. You have to tweak it for it to be considered an original work. If it is gotten from AI solely, it is not an original work. It is not distinct from every other thing, because at the end of the day, AI is also getting whatever it is feeding you from the internet, which is highly susceptible to plagiarism. And then it says that the final output must remain an authentic reflection of the author's own analysis. Over-reliance on AI-generated text without substantial human intervention risks a breach of academic integrity, as it obscures the true source of the ideas presented. So like I said, when you rely on AI-generated work without any human intervention, then it is not an original work. It cannot bypass anything. It's going to be seen as a generated work. It's going to be seen as AI-generated work. And then it's also important to know that consent is also important, especially when it comes to training data. If companies now, instead of just taking data sets without the consent of the owners, they should come out, they should ask for consent, they should seek consent to be able to get those data sets and then train their AI, so that issues such as fair use, all these cases would not be flying around, especially in this AI world that we see ourselves in. And there should be creative integrity. So this means that everybody should ensure that their work is free or almost free from AI generated text. So the last slide, please. Okay. Okay, conclusion. The intersection of AI and intellectual property represents one of the most significant legal frontiers of the 21st century. While AI offers unparalleled tools for innovation, it must not function at the expense of the human creators who provide its foundation. Moving forward, the goal should not be to choose between technological advancement and IP protection, but to develop a framework where IP acts as a force multiplier for human ingenuity, governed by transparency, fair use, and ethical accountability. So, conclusively, AI should not be a tool that renders intellectual property redundant. IP laws, intellectual property in essence, is to guide creative work made by human effort. AI is not supposed to come into play and scatter that. It is not supposed to come into play and render that useless. When it comes to intellectual property, there should not be a third creator. The machine should not be a third creator. Instead, AI should be used to refine whatever intellectual property is already in place, whatever intellectual property you want to make. It should not be used as the main tool. The human effort should be the main tool. The AI should be as an assistance or as a tool. And so by so doing, intellectual property would even gain more widespread understanding. And then it also says that there should be a framework. Some countries are already beginning to shape AI laws, shape how AI companies make use of data sets, shape how who owns some countries are already shaping how who owns a particular artistic work, whether it's the AI, whether it's the human. So by so doing, it would bring about a transparency, fair use, and ethical accountability, which would really help when it comes to intellectual property. Thank you.
All right, thank you very much, Angela, for a very wonderful presentation from you. Well done to you and to everyone who was able to put it together. So please, I would like to just kindly take a minute All right. So we would have to revisit this class, right? We would have to revisit this class another day. Unfortunately, our mentors just reached out to us that they are currently indisposed and they will not be able to join in for today's session, but promise that we can have a rescheduled session within the weekend, right? So I am trying to see how best we can do that, considering that we have other courses that are scheduled for within the weekend. So after maybe a little discussion with both mentors, we would be reaching out to you guys to set a day, right, on the weekend, probably even Sunday, right, so that we can eventually revisit this session. Seeing that we've already taken your presentation, we are just going to handle discussions and then we'll take questions, right? So I sincerely want to apologize that we have to make this change, right? It is just beyond our control right now. So once again, my sincere apologies for it. I will send a notice to your group to notify you of a day or a time that we have set for this particular course. So thank you, everyone. Okay, I can see somebody's hand up. Deola, please, you can go
Yes,
ahead.
sir. Sir, what about the group two that we presenting, sir?
Sorry, I didn't get you.
Group two, our presentation, sir.
Yes, I didn't get your question. What are you asking about?
Like, are we still going to present today or till when
No,
the meeting is? Oh,
no, you going to represent. The presentation is already done. So what we will just be having is the discussion on the topic. And
oh, group
um,
two.
yes,
Oh,
there were two that presented, right? In group one did,
okay, okay. I thought it was group one. Okay, sir.
no, it was group two who presented. So we are just going to be having a discussion and we will be taking we'll be having a
Okay,
discussion
sir.
and we'll be taking questions. So please let's get ready. I
Okay.
will notify you guys about the arrangements we'll be making in regards to that. Once again, like I said, my sincere apologies. Just beyond our controls, factors beyond our control right now. All right, please enjoy the rest of your day. Right. Please look out in your group for the details of how the session, the rescheduled session will be going. Thank you everyone and bye-bye.